Let me begin by giving you a bit of background on what the commission I work for, the National Human Rights Commission, or the NHRC, is and what it does. It was set up by an act in 1993, as Dr. Adesh Kumar told you, and by law the chairman must be a retired Chief Justice of India, another member must be a retired Judge of the Supreme Court, a third a retired Chief Justice of a High Court, and two other individuals with a knowledge of or practical experience in human rights. And we are all selected by a committee chaired by the Prime Minister, which includes the leaders of the opposition in both houses of Parliament. This is to ensure that there is no political bias in the choice of the members. What makes us perhaps unique among national human rights institutions is the range of powers we've been given under the Act. The Act stipulates that when inquiring into complaints, the Commission shall have all the powers of a civil court trying a suit under the Code of Civil Procedure, and we exercise this power to the fullest. As an example, at the recent meeting of the Asia-Pacific Forum of National Human Rights Institutions, which was held in Bali in Indonesia, our Australian colleagues reported that for the first time they had managed to implead themselves into an inquest in a death in police custody and had persuaded the coroner to accept that human rights had been violated. In other words, they had no independent power to come to that finding. But in India, the NHRC takes independent action. This is what happens. And again, Dr. Adesh Kumar has given you some of the details of what happens. All deaths in police or judicial custody or in police action must be reported to the NHRC within 24 hours. The Commission takes immediate cognizance and calls for the report of the inquest and the post-mortem, but also insists that a magisterial inquiry be held and the report sent to it. If these are not sent, the Commission can, and we do, summon the officers concerned to produce the reports or to explain why they have not done so. If, after examining these reports, the NHRC thinks that the magisterial inquiry has not established the truth, we then direct the state government to have an inquiry conducted by its criminal investigation department, which is expected to produce an impartial report. The record is a bit uneven. And therefore, if we are still not convinced, or if at the very outset we feel that in a particular case the police force of the state is complicit at fairly high levels, we know that we won't get an impartial inquiry from the state, and we therefore ask the central government to have an inquiry done by the Central Bureau of Investigation. And again, if there are delays or if the government jibs, we then summon the officers concerned. Once we are satisfied in the NHRC that a breach of human rights has taken place, we then take two further steps. We ask the state government concerned to pay relief to the next of kin of the victim. And we close our file only after we receive proof that the payment has been made. And though our directives are formally recommendations, not mandatory orders, these are very rarely disobeyed. And the second step we take is to ask the government to take punitive measures, either administrative or through prosecution, against the offenders, against the policemen or the others involved. I do not think any of our counterparts among the human rights institutions of other countries have the powers we do to establish official abuse and to give practical relief to the victims or to their families. We have also broadened the scope of official responsibility. In a narrow definition, the state is at fault if a prisoner has been tortured or killed by public servants. The NHRC, however, holds that it is the state's responsibility to ensure that the right to life of persons in its custody is protected at all times. This is where our medical experts are absolutely indispensable to us. Every case of death in custody, even of those who have died of illness, is examined to determine if they received the treatment that they needed. Wherever we have doubts, we call for the medical records and refer them to one of our specialists to check that the disease was diagnosed in time and correctly and that the right treatment was given. Even where magisterial inquiries have held that the death was natural, once our doctors tell us that there was a lapse in treatment, we hold the state culpable and have relief provided to the next of kin. In our view in the NHRC, and this I think is where we have, as I said, broadened the scope of the law, denying or delaying prompt medical care to a person in custody who is ill or dying is as much ill treatment as torture is. Prison wardens now know that they'll have to answer to the NHRC if a prisoner dies from neglect. And we believe that our interventions have helped lessen, not remove, but lessen the incidence of this form of ill treatment in Indian jails. We have also held that the state must accept responsibility for anyone who commits suicide in its custody. Almost invariably, when these are genuine suicides, and most of them are, magisterial inquiries come to the conclusion that no public servant was at fault. The NHRC's stand has been that in crowded Indian prisons and lockups, suicides cannot take place unless the custodians are negligent. We hold that it is the duty of the state to ensure that persons in its custody are not able to do any harm, either to others or to themselves. And we insist that in every case where a prisoner commits suicide in custody, relief be paid to the next of kin. There are other cases of suicide where, after examining the post-mortem report, we are not entirely persuaded that death could have taken place as reported. If it is not suicide, then it must be homicide. In these cases, we invariably consult an expert in forensic medicine on our panel to check if indeed the death could have taken place as reported. This, for instance, would be something the Commission would do in cases of partial hanging. If the forensic evidence is that the evidence did not quite establish a case of suicide, the Commission then asks for an inquiry to be conducted by the CID while recommending a higher quantum of relief for the next of kin. The NHRC has therefore gone well beyond almost any other institution in holding that the state must accept liability not only for deaths in police action, where those are not sanctioned by law, but also for deaths caused by custodial or police inaction. Having spoken of the ways in which the NHRC has widened the ambit of what constitutes torture or ill treatment, for which the state is liable, let me come to torture as narrowly defined and start by making it clear that this was banned by law in India even before it became a signatory to the UN Convention Against Torture. Article 21 of the Constitution lays down that no person shall be deprived of his life or personal liberty except according to procedure established by law. The Supreme Court has held that a right against custodial violence flows from this, and in several judgments, the courts have held that prisoners cannot be subjected to physical or mental restraints which are not warranted by sentences awarded by courts or in excess of the requirements of prisoners' discipline or which constitute human degradation. To ratify the convention, however, India must have a domestic law that specifically incorporates its provisions. The NHRC took the lead to persuade the government to adopt such a law which would distill its obligations under the UN Convention and sharpen the focus on the responsibilities of public servants. The Prevention of Torture Bill was drafted primarily with this very important procedural requirement in mind. The NHRC is aware that this is a flawed bill, and we have sent our comments on it on the draft bill, which is now in Parliament. Dr. Adarsh Kumar has given you the steps that have been taken by Parliament so far. The bill was introduced in April this year, passed by the lower house in May, and sent to the upper house, which on the 31st of August constituted a select committee, which has invited anyone with an interest in the issue to make submissions to it by the 22nd September. The deadline is now over. The NHRC was invited by the select committee to present its views at a meeting held on the 29th September, and we have done so. We've been asked by the select committee to send any further views we might have to it, and we will meet, all of us in the full commission, all 5 members, shortly to discuss what we might convey. However, in our work and in our ongoing work, the NHRC has not been handicapped, and I want to stress this, by the absence of a law specifically on torture. And the establishment of the NHRC has certainly helped, because our work shows that most of the victims of torture had a criminal background and were therefore themselves fearful of the law. They would not go to court to seek redress. They are terrified of the courts. And most of the other victims of torture are poor and from the weakest sections of society. Very few of them have the courage or the finances to take the state to court. They do, however, come to the NHRC, where a complaint can be made without any financial liability. We in the NHRC have used the framework of present laws, as the courts have, to bring redress to victims. Here again, forensic science has been invaluable to our work, because that is often the only basis on which we can establish that torture has taken place. Let me give you some rough numbers. In 2009-10, the NHRC received a total of 82,021 complaints on all issues. Of these, 29,800 were against the police. Of these complaints against the police, 615 were specifically about torture. And not for a moment in the NHRC do we believe that these were the only instances of torture. These were only the cases reported to us specifically alleging that a person or persons had been tortured. Under the other heads, in which we list charges made against the police to the NHRC, we had 5,700 cases of abuse of police power, 24 of abduction and rape by the police, 5 of custodial rape, 18 of custodial violence, 11 of attempted murder, 125 of atrocities on scheduled castes and tribes, 971 of unlawful detention, and 375 of victimization. Most of these, by definition, are torture in one form or other. And when we have investigated the more diffuse complaints, such as abuse of power, we have often found that ill treatment or torture was part of it. Wherever we are therefore able to establish that torture in the broadest sense has taken place, we recommend relief for the victim and action against the policeman concerned. However, it is clear, I think Mr. Subramaniam made this very clear, the mindset of policemen has to be changed. They must be made to realize that torture is not a tool of investigation, nor is it a privilege of office. This must be drilled into policemen, and training in human rights is therefore a must. In the NHRC, we are trying to assist with that training. Apart from speaking to officers, which we do, we realize that the torture normally takes place at the level of constables, the people who man the police stations. And so we are now developing a very ambitious training program for policemen across India, using our largest open university, the Indira Gandhi Open University, in which the obligation on policemen to abjure the use of torture is one of the modules. The course material is almost ready and the program should be launched shortly. The problem with many of these crimes committed by policemen, including torture, is that they are not visible. There are rarely any witnesses to torture. And this is an even greater problem in the last issue that I'll raise, which are extrajudicial killings, known in India as encounter deaths. Here the police file a charge sheet against the dead man or men for crimes under the Arms Act and for attempted murder, the attempted murder being the attempted murder of the policemen who killed them. The accused being dead, the courts usually accept the police statement and the cases are closed, with the police getting an apparent absolution and sometimes medals for what they had done. In the NHRC, we try to stop all this. We have made it a requirement that all cases of deaths in police action as in encounters must immediately be reported to it, and we have laid down that no promotions and no medals may be awarded until we've established that indeed these were justified. Here again, forensic evidence is a crucial and often only our only ally, because again by definition there are almost never any witnesses to an execution. So for instance, when a post-mortem records signs of blackening, charring and tattooing on a body, for instance, and the police claim an exchange of fire at a distance, we hold that its report is refuted by the forensic evidence. We hold that this was an execution and we recommend relief for the family. And we have done this and we have forced the state to pay to the families of hardened criminals, people with established criminal records, even in cases of those who are known as Naxalites. They are terrorists who have taken up the gun against the state. But when we have established that they were executed, not killed in an exchange of fire, we have forced the state to pay to the next of kin. And when one state government told us that this would encourage criminality, we asked the state to consider the import of what it was saying, that the state was basically telling the NHRC that henceforth criminals would be encouraged to get themselves shot so that their relatives could claim relief. So we have insisted that the state pay. Let me also say that this afternoon, through the help of Dr. Adarsh Kumar, who doesn't know this as yet, we established that the police was actually innocent in a case, because we had found a rather strange post-mortem report where the doctor had recommended blackening on internal organs, but no blackening on entry wounds. And this seemed such a forensic impossibility that we referred it to our specialist, Dr. Adarsh Kumar in this case, who then called for the explanations from the doctors concerned, who confessed that they had made a mistake because the lighting was poor and they had confused clotted blood on the internal organs with signs of blackening. So on the basis of Dr. Adarsh Kumar's advice, we have now actually absolved the policemen concerned, who otherwise would have been up a creek without a paddle, because we would have been after them. But we also hold the absence of forensic evidence against the state. When arms and ammunition are recovered and the police claim that these were used against them, forcing them to fire back in self-defense, we ask for a report from the forensic laboratory together with proof from gunshot residue that the man killed had fired the weapon. If the state is unable to produce the evidence or reports that the evidence was not collected, we hold that the presumption must be that the policemen concerned did not follow basic operating procedures because they wanted to suppress the truth. So the onus is on the police to explain why they didn't do it, and if they cannot, we reject the police report in these cases and hold that the encounter was fake. Now, what are the numbers involved? In 2009-10, the same period on which I spoke about the torture, incident of torture, the NHRC received reports from the police of 105 deaths in police encounters. Now, every death in police action must be and is reported to the Commission. So these figures, unlike the figures in torture, are reliable. Our investigations show that a fair percentage of these encounters are genuine. with deaths taking place in exchanges of fire between criminals or terrorists and the police. But equally, in a fair number of cases, we are able to establish with the help of our forensic experts that the encounter was fake. And this is very disturbing because the Supreme Court has held that the death penalty can be imposed only in what it calls the rarest of rare cases. And only one man has been executed in India over the last decade on court orders. So therefore, through these extrajudicial killings, the police are taking the law into their own hands, subverting the orders of the Supreme Court, and that cannot be permitted. Which is why we in the NHRC are so active on this issue. So that, ladies and gentlemen, is an overview of the work that the NHRC does in this sector, in which, as I said, the assistance of forensic science and of forensic experts has been invaluable to our work. Thank you.